This exam focuses on the civil and criminal courts, the legal professions and access to justice. This exam will also focus on the rules and general elements of criminal law and provides an introduction to criminal liability through the study of offences against the person and offences against property.
Civil courts are the main method of resolving civil disputes. However, there are other methods of solving these disputes. The aim of civil law is to protect people and businesses in society and ensure their rights are not infringed on. The outcome for civil courts is compensation for the claimant or an injunction on the defendant. Civil cases can start in county courts or high courts depending on the complexity of the case and the amount that is being claimed. The procedure to get into the civil court system depends on which court the parties are starting in. If the parties are using the county court, the claimant can choose to issue the claim with any of the 200 county courts. If the parties are using the High Court, the claimant can go to one of the 20 district registries or the main court in London. When starting a claim, the claimant fills out an N1 form, which outlines the details of the case. When the defendant receives the N1 claim form, they can admit the claim and pay the full amount, or they can dispute the claim. The defendant can also do nothing, and the claimant can ask the court to make an order that the defendant pay the money or costs claimed. The county court's main jurisdiction is to hear all contract and tort cases, hear cases for the recovery of land, and hear disputes for equitable matters. The High Court's main jurisdiction is to hear all civil cases. The High Court has 3 divisions: the King's Bench Division, the Chancery Division, and the Family Division. The King's Bench Division has 70 judges and has the main purpose of regulating the courts and dealing with appeals. The Chancery Division has 17 High Court judges and has the main purpose of dealing with matters such as insolvency, mortgages, and patents. The Family Division has 17 High Court judges and has the main purpose of hearing cases relating to children and family. There are 3 tracks that a civil claim can go into: the small claims track, the fast track, and the multi-track. The small claims track is for claims up to the value of £10,000 but is limited to £1,500 for personal injury. These cases are heard by a district judge. The hearings are a maximum of 3 hours with a limited number of witnesses. Both the claimant and the defendant are encouraged to represent themselves to help reduce the costs. The advantages of using the small claims track are that it is cheap, quick, the parties represent themselves and they can receive help from the judge. However, the disadvantages of using the small claims track is that there is an allocation fee, there is no legal funding, the judge usually is not helpful, and the claimant may not get the money that they are claiming. The fast track is for claims up to the value of £25,000. These cases are heard within 30 days and the hearing is a maximum of 1 day. For these cases, the court can set a strict timetable for pre-trial matters. If the parties don't follow this timetable, the case can be thrown out or the judgment in default can be awarded. The advantages of the fast track is it is fast, witnesses can be used and the parties can have legal representation. However, the disadvantages of the fast track is that it still takes a long time. The parties are limited to 1 witness and the cost of legal representation may be higher than the amount being claimed. A multi-track is for claims between the value of £25,000 and £100,000 for the county court and in any amount over £100,000 for the High Court. These cases are heard by a circuit judge who can set a strict timetable, the disclosure of relevant documents, the number of witnesses, and how long the case will last. The case for this track will last approximately 3 years and is the most expensive track as the parties may have to pay lawyers. The advantages of the multi-track is that there are unlimited witnesses, the parties can have legal representation, and complex cases are dealt with by a specialist. However, the disadvantages of the multi-track is that it lasts a long time. There are no limits to the cost. There are so many cases that the courts cannot cope with the demand and complex cases may be of usual value. If one of the parties in the case feel the ruling of the case was incorrect for any reason, they can appeal the decision to a court that is higher in the hierarchy. In order to do this, the individual needs permission to appeal that case from a judge. As well as this, the judge will only grant permission for the appeal if the individual has the proper legal grounds for the appeal, or the judge believes that there was an error that affected the fairness of the result. The appeal route for the small claims track starts at the county court with a district judge. This moves to the High Court with a circuit judge. This will move to the Court of Appeal, which will then move on to the Supreme Court. The appeal route for the fast track starts at the county court with a circuit judge. This moves to the High Court with a High Court judge. This will move to the Court of Appeal, which will then move on to the Supreme Court. The appeal route for the multi-track starts with a circuit judge, either in the county court or the High Court. This can move to the Court of Appeal, which will then move on the Supreme Court. There are many reasons for appeals in the civil court system. There can be an appeal from the district judge to circuit judge if the law was applied incorrectly, there was an error in the facts of the case, the procedure was not followed properly, or the judge's decision was incorrect. There can be an appeal from the circuit judge to a high court judge if the law was applied incorrectly, there was an error in the facts of the case, the procedure was not followed correctly, or the judge exercised their discretion improperly. There can be an appeal from the circuit judge to the Court of Appeal if there is an error in the law, there was an error in the facts of the case, the procedure was not followed correctly, or the case raises issues of public importance. There can be an appeal from the High Court judge to the Court of Appeal if the law was applied incorrectly, there was an error in the facts of the case, the procedure was not followed correctly, the judge exercised their discretion incorrectly. There can be an appeal from the Court of Appeal to the Supreme Court if the point of law is of general public importance, there is a conflict in existing case law, or the Court of Appeal's decision is unjust. The advantages of using civil courts is that the process is fair as everyone is treated equally and the judge is impartial. As well as this, it is easy to enforce the court's decision, there is an appeal process, and the parties can receive legal aid. However, a disadvantage of using civil courts is that the cost of taking a case to court is often more than the amount that is being claimed. As well as this, legal cases are a long and complicated process, and the preliminary stages add to the length of the case. In addition, there is no guarantee of winning a case, and the party that loses the case may have to pay for the legal costs of the other party. Alternative dispute resolution is any method of resolving a dispute without going to court. The four main methods of alternative dispute resolution is negotiation, mediation, conciliation, and arbitration. Negotiation is the act of resolving a dispute by negotiating directly. Mediation is where a neutral third party consults each party to find common ground between them. Conciliation is where a neutral third party suggests grounds for compromise and possible basis for a settlement. Arbitration is where the parties submit their dispute to someone else's judgment, with the arbitrator's decision being final and legally binding. Some commercial contracts may have a Scott v. Avery clause, which states that the parties will use arbitration in order to resolve a dispute if they have one. The advantages of using alternative dispute resolution are that it is cheaper and quicker than using the civil courts. However, the disadvantages of using alternative dispute resolution are that they may not work, and most methods are not legally binding. Tribunals are a specialist court system that gives people the method of enforcing certain social rights. An employment law tribunal deals with claims against employers by employees. There are 3 members of the tribunal panel that will decide the case. These members are the employment judge, the person representing the employer, and the person representing the employee. The advantages of using tribunals is that the costs are low and the hearings are short. As well as this, the members of the panel hearing are usually experts in the case, which gives the best result for the case. However, the disadvantages of using tribunals are that legal funding is usually not available and there can often be delays in getting the hearing. Criminal courts are the method used to deal with criminal offences, with lay people making the decisions in these court cases. The criminal process starts in the magistrate's court, which hears 97% of all criminal cases. The magistrate's court has the jurisdiction to hear all summary offences, some tribal either way offences, and the first hearing of indictable offences. A magistrate's court has the power to sentence an offender to a maximum of 12 months imprisonment, give unlimited fines, and give a conditional discharge. The other main court that hears criminal cases is the Crown Court, which has the jurisdiction to hear some tribal either way offences and indictable offences. The Crown Court has unlimited sentencing powers and the power to hear appeals from the Magistrates' Court. There are 3 classifications of offences: summary, tribal either way, and indictable. Summary offences are the least serious offence and are heard in the Magistrates' Court. Examples of summary offences include driving without insurance, common assault, and criminal damage under £5,000. Tribal either way offences are middle-range crimes and can be heard in the Magistrates' Court or the Crown Court. The case will be heard in the Magistrates' Court if the defendant pleads guilty and the court has the power to sentence the defendant. If the defendant pleads not guilty or the magistrate's court does not have the power to sentence the defendant, the case will be sent to the Crown Court. Examples of tribal either way offences include theft, assault causing ABH, and obtaining property by deception. Indictable offences are the most serious crimes and are heard in the Crown Court, although the first hearing is heard in the Magistrates' Court. Examples of indictable offences include murder, manslaughter, rape, and robbery. Before the trial, there is an initial hearing where the defendant must plead guilty or not guilty. If the case is a triable either way offence and the defendant pleads guilty, the case will stay in the magistrate's court as long as they have the power to sentence the defendant. If the magistrate's court does not have the power to sentence the defendant for their crime or they plead not guilty, then the case will be sent to the Crown Court. After the initial hearing, there is a bail hearing. This is where the court decides whether the defendant should be put on bail or remain in custody until the trial. After the bail hearing, there is an arraignment where the defendant is formally charged with their crime and they will receive information about the charges and their rights. After this, there will be motions, which are applications that cover various aspects of the case. These motions will include the exclusion of certain evidence, change of venue, or the dismissal of the charges. The appeal route for criminal cases starts in the Magistrates' Court and will move on to the Crown Court. After this, the case can be appealed to the King's Bench Division of the High Court, which can be from either the Crown Court or the Magistrates' Court. The case can then move on to the Court of Appeal and then the Supreme Court. A case can be appealed from the Magistrates' Courts to the Crown Court if the sentence was too harsh or it is believed that the defendant should not have been convicted. A case can be appealed from the Magistrates' Court to the King's Bench Division of the High Court if there is a mistake in the law or the law is applied incorrectly by the magistrates. A case can be appealed from the Crown Court to the King's Bench Division of the High Court if the law is applied incorrectly or there is evidence of a corrupt jury. A case can be appealed from the Crown Court to the Court of Appeal if the evidence was so weak that the defendant should not have been convicted based on it. There can also be an appeal if the law is wrong or if the sentence was too harsh. A case can be appealed from the Court of Appeal to the Supreme Court if the case involves a point of law that is of general public importance. Section 142 of the Criminal Justice Act sets out the aims of sentencing offenders. These aims are restitution, denunciation, individual deterrence, general deterrence, rehabilitation, public protection, and reparation. Restitution is where the offender is punished for their actions. Denunciation is where society expresses their disapproval for and condemns criminal activity. Individual deterrence tries to ensure the offender does not reoffend. General deterrence tries to prevent any potential offenders from committing crimes. Rehabilitation tries to reform the offender and get them back into society. Public protection is the aim of making the public feel safer by putting the offender in a place where they cannot commit a crime. Reparation tries to repair the damage done by the offender's crime, either by compensating the victim or by having the offender to community service. There are two types of factors that affect the sentence given to an offender, which are aggravating factors and mitigating factors. An aggravating factor increases the sentence that is given. These factors include any previous convictions, offences committed while on bail, any racial or religious hostility being used, any hostility towards disability or sexual orientation, or the lack of remorse. Mitigating factors decreases the sentence that is given. These factors include previous good character, youth or old age, domestic problems or ill health, remorse shown after the offence, a guilty plea, or helping the police with the investigation. There are two types of sentences that can be given to adults. These are custodial sentences and non-custodial sentences. A custodial sentence is where the offender is imprisoned for a specific period of time. This includes a mandatory life sentence, which is imposed if the offender has committed a crime where they have to be punished with a life sentence. With this punishment, the judge states the minimum number of years that they have to serve before they are eligible to be released. Custodial sentences also include a discretionary life sentence where the maximum sentence is life imprisonment, but the judge does not need to impose it. Custodial sentences also include a fixed term sentence where the offender has to serve a fixed number of years for their crime but is automatically released after serving half of their sentence. A non-custodial sentence or community order punishes the offender without imprisonment. This includes an unpaid work requirement where the offender has to work between 40 and 300 hours on a suitable project. Non-custodial sentences also include a prohibited activity requirement where the defendant cannot do certain activities to prevent them from committing another crime. Non-custodial sentences also include a curfew requirement where the offender has to remain at a fixed address between 2 and 16 hours a day. Non-custodial sentences also include an exclusion requirement where the offender cannot go to certain places in order to keep them away from areas where they are likely to commit crime. Non-custodial sentences also include a residence requirement where the defendant has to live in a certain place for a certain period of time. Non-custodial sentences also include a drug or alcohol rehabilitation requirement where the offender receives treatment to reduce their dependency on drugs or alcohol and must give samples for testing. Non-custodial sentences also include fines, which is an amount that the offender can afford but is not paid to the victim. Non-custodial sentences also include discharges where there is no punishment. A conditional discharge means the offender is not punished for their crimes as long as no further offence is committed for up to 3 years. An absolute discharge means the offender is not punished and there is no formal conviction recorded against them. Lay people are the people that are used to make legal decisions. There are two types of lay people, the magistrates and juries. A magistrate sits in the magistrates' court in a panel with two other magistrates. To be a magistrate, a candidate must be between the ages of 18 and 70 and are expected to live or work in or near the local justice area, which is the area their court is located. As well as this, the candidate must be prepared to commit to working 26 half days for 1 year or 13 full days for 5 years. Magistrates do not require any qualifications, but they do require certain character requirements. These requirements include a good character, good understanding and communication skills, social awareness, maturity and sound temperament, sound judgment, commitment and reliability. There are certain restrictions that prevent a candidate from becoming a magistrate. These restrictions include having serious criminal convictions, having been bankrupt in the past, being a member of the forces, those whose work is incompatible, such as being a police officer or a traffic warden, those who have impaired hearing, those who are not physically or mentally strong, and those who have a relative working in the criminal justice system. When being appointed, the candidate must go through a two-stage interview process. In the first interview, the interviewers find out the candidate's personal attributes and explore their attitude for criminal justice. In the second interview, the interviews test the candidate's potential for judicial aptitude. The local advisory committee then interviews the candidate and submits the candidate names to the Lord Chancellor. The Lord Chancellor then appoints magistrates based on the recommendations from the local advisory committee. The role of a magistrate is to deal with summary offences and tribal either way offences where they will decide the verdict and the sentence. Magistrates also have to deal with the preliminary hearings for all criminal cases and deal with the first hearing for indictable offences. A juror sits in the Crown Court with 12 other jurors. To be a juror, the candidate must be between the ages of 18 and 75 and must be on the electoral roll. As well as this, the candidate must originally be a resident of the UK or the Isle of Man or be a resident for at least 5 years since their 13th birthday. A candidate may be disqualified from doing jury duty. A candidate may be permanently disqualified if they were sentenced to life imprisonment, they were detained for His Majesty's pleasure, they served a term of imprisonment for public protection, they had an extended sentence, or they served a term of imprisonment for 5 years or more. A candidate may be disqualified for 10 years if they served a term of imprisonment of under 5 years, had a suspended sentence, were given a community order. Any candidate who is on bail or has a mental illness are disqualified. A judge can discharge a juror if they lack the capacity to cope with the trial and fulfill the roles of a juror. This may be because they do not understand English or they have a disability that prevents them from completing their duties, such as blindness or deafness. When selecting a jury for a hearing, the list of potential jurors is divided into groups of 15 and allocated to a court. The court clerk will select 12 of these 15 potential jurors. When the jurors arrive at the hearing, they are shown a video that explains the court layout and procedure and tells the jurors how to behave. The role of the jury is to decide whether the defendant is guilty. To do this, the jury will retire to a private room and make their decision on the guilt or innocence of the defendant. An advantage of using juries in criminal cases is that they do not need to give a reason for their verdict, so they can decide the case according to their idea of fairness. As well as this, the jury helps make the legal system more open and allows the public to have more confidence in the criminal justice system. However, a disadvantage of using juries in criminal cases is that there have been instances where the juries have refused to convict when the outcome is clear. As well as this, there may be pressure from the media and a lack of understanding which will affect the verdict that the jury comes to. Legal personnel includes lawyers and judges. There are many different types of these, each with different roles that they fulfill. Anyone in the legal profession is a lawyer, which is someone who practices law. There are 3 types of lawyers, including barristers, solicitors, and legal executives. A barrister is a legal professional who specializes in courtroom advocacy, representing clients in higher courts and providing expert legal opinions. Barristers are regulated by professional bodies such as the Bar Standards Board in the UK, which sets ethical standards, oversees training, and enforces disciplinary actions. A solicitor is a legal professional who provides general legal advice, prepares legal documents, and handles client representation outside of court, often referring complex cases to barristers. Solicitors are regulated by governing bodies like the Solicitors Regulation Authority in the UK, which ensures they meet professional standards, adhere to ethical codes, and maintain competence through ongoing training and compliance measures. A legal executive is a qualified legal professional who specializes in a specific area of law, performing similar work to solicitors, but with a focus on particular legal tasks and often with a different route of qualification. Legal executives are regulated by the Chartered Institute of Legal Executives in the UK, which oversees their training, professional conduct, and adherence to ethical standards. A judge or the judiciary collectively is a legal authority responsible for interpreting and applying the law, resolving disputes, and ensuring justice is administered fairly and impartially in court. There are two types of judges, which are superior judges and inferior judges. Superior judges are the most qualified judges and have the most experience sitting in the High Court, Court of Appeal, and Supreme Court, handling more complex and significant legal cases. Superior judges include justices of the Supreme Court, Lord Justices of Appeal, and High Court judges. Justices of the Supreme Court sit in the Supreme Court and have the role of interpreting the Constitution, reviewing lower court decisions, and making final rulings on significant legal issues, ensuring uniformity and fairness in the law. Lord Justices of Appeal sit in the Court of Appeal and have the role of hearing and determining appeals from lower courts, reviewing legal decisions to ensure they are correct and just. High Court judges sit in the High Court with the role of hearing significant and complex cases at first instance, including civil, family, and some criminal matters, and oversee judicial reviews and appeals from lower courts. Inferior judges are judicial officers in the county courts and crown courts, handling routine and less complex cases, including preliminary hearings and minor legal matters, without the authority to review higher court decisions. Inferior judges include circuit judges, recorders, district judges, and tribunal judges. Circuit judges preside over cases in the Crown Court and civil cases in the High Court, handling a broad range of criminal, civil, and family matters at a regional level. Recorders are part-time judges who sit in the Crown Court, handling criminal cases and assisting with civil matters, often contributing their expertise on a temporary or sessional basis. District judges hear cases in the county courts, managing civil disputes, small claims, and some family matters, ensuring fair and efficient resolution at a local level. Tribunal judges sit in the tribunals with the role of resolving disputes and making decisions on specialized matters such as employment, immigration, and social security issues within specialized tribunal systems. The separation of powers is a principle of government that divides government responsibilities into distinct branches to prevent any one branch from gaining too much power. The executive is the government consisting of the Prime Minister and government ministers who make policies and draft the law. The legislature is the House of Commons and the House of Lords who make the law. The judiciary are judges who enforce and interpret the law but can also make some laws. There are methods that are used to ensure that the judiciary are independent. These include security of tenure, immunity from suit, independence from the other two arms of the state and their independence from the case. Security of tenure is the guarantee that judges cannot be removed from office without just cause, which ensures judicial independence by allowing them to rule impartially without fear of punishment or influence from external pressures. Immunity from suit protects judges from being sued for actions during their role as a judge, ensuring judicial independence by allowing them to make decisions based on the law without fear of personal legal repercussions. Independence from the other two arms of the state means that the judiciary operates free from interference or influence by the executive and legislative branches, ensuring judicial independence by allowing courts to make unbiased decisions based solely on the law and justice. Independence from the case means that judges must have no personal interest or bias in the outcome of a case, ensuring judicial independence by allowing them to make impartial decisions based solely on the facts and law. The advantage of the judiciary is that it is independent of the state and politicians and are not under pressure to impress the electorate. As well as this, the judges are more effective and quicker than lay people as they do not need to come to an agreement with other people. However, a disadvantage of the judiciary is that they lack transparency in appointment and disciplinary issues. As well as this, there are issues with inconsistency, particularly in the sentencing in lower courts. The advantages of judicial independence are that judges can make impartial decisions, they can uphold the rule of law and better protect the rights of individuals. As well as this, the judiciary acts as a check on the power of the executive and the legislature, maintaining a balance in government. In addition, the judiciary's independence builds the public's trust and provides long-term stability for the legal system. However, the disadvantages of judicial independence are that judges are not accountable to the public, and judges may interpret laws based on their personal or political beliefs. As well as this, judges may be isolated from public opinion and are at risk of corruption. Justice can be accessed in many ways, which can be through help with funding the case or simply providing advice. Government funding for civil and criminal cases comes from many sources, including the Legal Aid Agency, court fees remissions, and litigation funds. The Legal Aid Agency is an executive agency responsible for providing legal aid funding in both civil and criminal cases. Civil legal aid covers many civil matters, including family disputes, housing issues, and immigration cases. In order to be eligible for legal aid in civil cases, the Lord Chancellor must consider several factors before granting legal funding for the case. These factors are the cost and benefit of providing the services, the availability of resources, the importance for the individual's prospect of success in the dispute, and the public interest. Public funding is not available for contract cases or tort cases. Criminal legal aid covers legal advice, representation, and the cost for defendants who cannot afford legal services. In order to be eligible for legal aid in criminal cases, the defendant must qualify under the interest in justice criteria. These criteria are likely to lose their liberty or livelihood involves a point of law. The individual is unable to understand the proceedings. The case involves the tracing, interview, or expert cross-examination of witnesses, or it is in the interest of another person that the individual be represented. There are additional criteria that the individual must meet in order to receive legal aid in the Magistrates' Court and the Crown Court. To qualify for legal funding in the Magistrates' Court, the applicant must qualify for under the interest in justice criteria and pass the full means test. To pass the full means test, the applicant must have a disposable income of less than £3,398 or have a gross income of below £22,325. In the Crown Court, anyone with a disposable income below £37,500 will automatically receive representation. If the applicant does not meet these criteria, then they will not receive legal aid. Advantage of the Legal Aid Agency is that it provides legal representation for people who cannot afford it, which ensures access to justice. As well as this, the Legal Aid Agency covers a wide range of legal issues in both civil and criminal cases. However, a disadvantage is that there is limited availability, as there is a limited budget and strict criteria that the individual has to meet, which can prevent people from accessing justice. As well as this, the application process for legal aid is a long and time-consuming process. The impact of the changes to the legal aid budget is that fewer people are able to access free legal representation, which limits their ability to pursue justice. As well as this, these changes have led to longer wait times and a reduced quality of service, as there are fewer legal aid resources. In addition, individuals who cannot afford private legal representation are more likely to represent themselves in court, which can lead to less favorable outcomes. Another impact is that there is more inequality in the legal system, as access to justice depends on an individual's financial resources. In addition, the overall reduction in legal aid availability has an impact on society, as it reduces the ability to challenge unfair practices and protect the rights of vulnerable groups. Another source of government funding is court fees remissions for anyone who cannot afford the court fees for a civil case. An advantage of fee remissions is that they make the legal system more accessible by reducing or removing court fees for individuals who cannot afford them. As well as this, fee remissions ensure that financial barriers do not prevent people from pursuing justice in civil cases. In addition, they provide support to people who may be unable to access the legal process due to their financial situation. However, a disadvantage of fee remissions is that the eligibility criteria can be strict, meaning not everyone who struggles financially will qualify. As well as this, the application process can be complex and time-consuming, which might deter some individuals from seeking this assistance. In addition, fee remissions only cover court fees and do not address the broader costs of legal representation. The government also provide limited funds for litigation in public interest that involves human rights. An advantage of specialized government funds for public interest litigation is that they provide financial support for cases that have a large impact on society, allowing important legal issues to be addressed in court. As well as this, these funds enable individuals or groups who might be unable to afford litigation to challenge unfair practices or policies that affect the public. However, a disadvantage of specialized government funds is that they are often limited in amount and availability, meaning only a small number of cases can be supported. As well as this, the application process for these funds can be competitive and challenging, which may discourage them from applying for them. There are many other methods of accessing justice, including private funding, conditional fees, and advice agencies. The defendant may be able to afford their own legal funding. However, consulting a solicitor can be expensive, with a solicitor outside of London averaging £150 an hour and solicitor in London being around £600 to £1,000 an hour. An advantage of private funding is that individuals can choose their preferred legal representation and have more control over the legal process. As well as this, the individual will have the ability to hire highly specialized lawyers for their case. In addition, this often leads to a quicker service, as there are not the limitations of government or pro bono services. However, a disadvantage of private funding is that the cost of legal fees are often high, which can make this option inaccessible to many individuals. As well as this, if the client loses the case, then they will lose the full cost of the legal fees and will not win anything back. In addition, private funding increases inequality, as the access to justice is based on the finance available to each person. Because the cost of a case can be expensive, the solicitor and the client will agree on a fee that will be paid if the case is won. If the case is lost, the client will not pay a fee. An advantage of conditional fees is that the client only pays the legal fees if they win the case, which makes legal services more accessible. As well as this, lawyers will be more motivated to win the case. However, a disadvantage of conditional fees is that if the case is won, the lawyer's fees may be higher than the standard rate, which can reduce the compensation that the client receives. As well as this, lawyers may only take on cases where they are confident that they will win, as not all cases are suitable for a conditional fee agreement. There are many agencies that provide legal advice, including citizens' advice, law centers, pro bono units, free representation units, trade unions, insurance companies, and charities. Citizens' advice provides free, confidential advice on legal and other issues, helping individuals understand their rights and provide access to the necessary services. Law centers offer free legal advice and representation to people who cannot afford it, focusing on social justice issues. Pro bono units provide free legal services provided by lawyers to individuals who cannot afford legal representation. Free representation units provide free legal representation for individuals in social security and employment tribunals. Trade unions offer legal support and representation to their members, particularly in employment-related disputes. Insurance companies provide legal cover as part of insurance policies, covering legal fees for certain types of claims. Charities offer specialized legal advice and support for vulnerable groups, often focusing on specific issues such as domestic violence or immigration. An advantage of advice agencies is that they provide free or low-cost legal advice, making legal support accessible to individuals with limited funds available. As well as this, advice agencies are often community-based, which means they are easily accessible and approachable for those in need of assistance. In addition, advice agencies address a broad range of issues beyond just legal matters, which helps clients navigate various aspects of their situations. However, a disadvantage of advice agencies is that they may not offer full legal representation or cover all types of legal issues, focusing primarily on advice and initial support. As well as this, advice agencies often face resource constraints, relying on donations, government funding, or volunteer support, which can limit the availability and quality of their services. In addition, the high demand for these services can lead to long wait times or limited availability of appointments. A crime is an act or omission that violates the law and is punishable by the state. There are many sources, principles, and purposes of criminal law. There are 4 sources of criminal law, which are statutory law, common law, constitutional law, and international law. Statutory laws are the laws implemented by Parliament. Common law is the past decisions of judges that establish precedent that must be followed by future judges. Constitutional laws are the principles established in the Constitution. International laws are the treaties and agreements between nations that influences the criminal law of each nation. Criminal liability is the legal responsibility of an individual for committing a crime established by meeting the required elements of a criminal offence. The elements of criminal liability are actus reus, mens rea, concurrence, causation, harm, and legality. Actus reus is the physical act or conduct that constitutes a criminal offence. Mens rea is the mental state or intent of the person committing the crime. Concurrence is the requirement that the actus reus and mens rea occur together. Causation is the need to establish that the defendant's actions directly caused the harm or result. Harm is the actual damage or injury caused by the criminal act. Legality is the principle that the conduct must be defined as criminal by law before it can be punished. In a criminal case, there are two sides, which are the prosecution and the defense. The prosecution represents the government or state and brings charges against the accused individual. In the case, the prosecution must present evidence, prove the defendant's guilt beyond a reasonable doubt, and seek justice on behalf of society. The defense represents the accused individual and protects their legal rights. In the case, the defense must challenge the prosecution's evidence, provide counter-arguments, and seek to prove the defendant's innocence or mitigate the charges. The burden of proof is the obligation to prove that the defendant committed the crime. In a criminal case, the burden of proof is on the prosecution, which must establish the defendant's guilt. The standard of proof is the level of certainty required that the defendant actually committed the crime. For criminal cases, the standard of proof is beyond reasonable doubt, which means that the evidence must leave no reasonable doubt of the defendant's guilt. Reverse onus is a situation where the burden of proof shifts from the prosecution to the defendant. This often applies in certain defenses or specific legal contexts, such as proving an exception to a statutory crime, but not generally in proving guilt. There are many aims and purposes of criminal law, including deterrence, retribution, rehabilitation, incapacitation, and restoration. The purpose of deterrence is to prevent individuals from committing crimes by imposing penalties and creating a fear of punishment, with the aim being to reduce crime rates and influence behavior through the threat of legal consequences. The purpose of retribution is to ensure that offenders receive a punishment proportionate to their crime, with the aim to deliver justice by holding individuals accountable for their actions and satisfying social ideas of moral balance. The purpose of rehabilitation is to reform offenders so they can reintegrate into society as law-abiding citizens, with the aim being to address underlying issues such as addiction or mental health to prevent future offenses. The aim of incapacitation is to protect society by removing dangerous individuals from the community, with the aim being to prevent further criminal behavior by restricting the freedom of those deemed a threat. The purpose of restoration is to repair the harm caused by criminal acts to victims and communities, with the aim being to promote restitution and reconciliation through processes like victim-offender mediation and community service. There are many principles of criminal law, including legality, presumption of innocence, burden of proof, mens rea, actus reus, concurrence, causation, proportionality, and double jeopardy. Legality is the principle that no one can be prosecuted or punished under the law unless their conduct was defined as criminal by statute before it was committed, which ensures that laws are clear and predictable, preventing retroactive prosecution. The presumption of innocence is the principle that every individual is considered innocent until proven guilty, which protects the rights of the defendant and ensures that the burden of proof is on the prosecution. Burden of proof is the principle that the prosecution must prove the defendant's guilt beyond a reasonable doubt, which ensures a high level of certainty before depriving an individual of liberty or other rights. Mens rea is the principle that criminal liability generally requires a guilty mental state or intent, which ensures that only those who intended to commit a crime or were recklessly indifferent are punished. Actus reus is the principle that a crime consists of a physical act or omission that breaches the law, which ensures that punishment is based on actual conduct rather than mere thoughts. Concurrence is the principle that the actus reus and mens rea must occur together for a crime to be established, which ensures that the mental state aligns with the criminal act. Causation is the principle that the defendant's actions must be the direct cause of the harm or result, which establishes a clear link between the defendant's conduct and the resulting damage. Proportionality is the principle that the punishment should be proportionate to the severity of the crime, which ensures fairness and justice by aligning the severity of the punishment with the nature of the offense. Double jeopardy is the principle that a person cannot be tried twice for the same offense once acquitted or convicted, which protects individuals from multiple prosecutions for the same conduct, ensuring legal finality. There are two general elements for criminal liability, which are actus reus and mens rea. Actus reus is the act of committing a crime. This act must be done voluntarily for there to be a criminal conviction. There are two types of crimes that involve actus reus, which are conduct crimes and consequence crimes. A conduct crime is where a specific act is prohibited, such as smoking in a public place. A consequence crime is where the outcome of the act is illegal, such as death. A voluntary act is when an individual performs an act willingly or with control over their actions, as shown in Hill v. Baxter. An involuntary act or state of affairs occurs when there is no criminal act or intent, but a crime was still committed, as shown in R v. Larsenau. An omission is when an individual fails to act. There are 6 types of omission, which are contractual duty omission, official position omission, voluntary omission, relationship omission, dangerous situation omission, and statutory omission. A contractual duty omission occurs when an individual has a duty to act under their employment but fails to act, as shown in R.V. Pitwood. An official position omission occurs when the individual has a position of authority or care and they fail to act, as shown in R.V. Ditham. A voluntary omission occurs when an individual takes on responsibility for someone's care but fails to act, as shown in Stone and Dobinson. A relationship omission occurs when an individual has a legal duty to act due to a relationship that they have with another person, but they fail to act, as shown in Gibbons and Proctor. A dangerous situation omission occurs when the individual creates a dangerous situation that and fails to prevent the harm that it will cause, as shown in R.V. Miller. A statutory omission occurs when an Act of Parliament creates a duty to act, such as the Road Traffic Act. Causation is when an event or consequence is brought about by the defendant's actions. There are 2 types of causation, which are factual and legal causation. Factual causation uses the but test, which proves whether the outcome would have occurred without the defendant's actions, as shown in R.V. White. Legal causation requires the defendant's actions to have a more than slight and trifling link with the outcome and for the defendant's actions to be a more than a minimal causation of the outcome, as shown in R.V. Hughes. The thin skull rule means the defendant must take their victim as they find them. This means that if the defendant chooses a weaker victim and they suffer more harm than a normal victim would, then the defendant is guilty of the full harm that is caused. This is shown in R.V. Bloor. Novus actus interveniens is an event that happens after the act of an individual which either causes or contributes to the outcome. There are 3 types of novus actus interveniens that can break the chain of causation between the defendant's actions and the outcome. The first type of novus actus interveniens is the act of the third party, as shown in R.V. Smith. The second type of novus actus interveniens is the victim's own actions, as shown in R.V. Roberts. The third type of novus actus interveniens is a natural, unpredictable event. Mens rea is the mental element of a crime. Fault is the guiltiness of the defendant's state of mind while the crime is being committed, as shown in R.V. Cunningham. Intention is where the defendant desired a specific consequence to come from their actions, as shown in R.V. Steen. There are 2 types of intent, which are direct and indirect intent. Direct intent is where the outcome was the defendant's main aim, purpose, and desire, as shown in R.V. Mohan. Indirect or oblique intent is where the defendant saw the possible consequences are virtually certain, but ignored the risk and continued with their actions anyway, as shown in R.V. Woolen. The defendant may have been reckless in their actions, which is when an individual acts in a way that makes it more likely that harm will occur, as shown in R.V. Cunningham. Negligence is the omission to do something that a reasonable person would do, or doing something that a reasonable person would not do. Negligence becomes gross negligence if the defendant's omission is so extreme that the jury must consider it illegal, as shown in R.V. Anamarco. Strict liability at crimes that require no proof of mens rea. There are 5 criteria that are used to establish strict liability. The first criterion is to presume that mens rea is required for the crime, as shown in PSG BV Storcoin. The second criterion is that the more criminal the crime, the harder it is to remove mens rea, as shown BV DPP. The third criterion is that the statute must state or imply that mens rea is needed for the crime, as shown in Cundy v. Leclerc. The fourth criterion is that the crime must concern public interest or safety, as shown in Camo v. Tilstone. The fifth criterion is that the offence must impose a small penalty, as shown in R.V. Howells. If the crime requires mens rea, which stated or implied by the statute concerns public interest or imposes a larger penalty, then the crime will not be strict liability. Transferred malice is where the mens rea is transferred from one offence to another. This occurs when the defendant intends to commit a crime against the victim but ends up harming a different victim, as shown in R.V. Pembleton. The coincidence of mens rea and actus reus means that the guilty mind and the criminal act must occur together for an offence to be established. A continuing act is when the actus reus and the mens rea occur at the same time, as shown in Fagan v. Metropolitan Police Commissioner. A transactional act is where there is a clear series of events and the mens rea is formed at some point in the series of events, as shown in Thobbo-Melly. A fatal offence is a crime that causes the death of a person. There are 3 fatal offences that can be committed against an individual, including murder, voluntary manslaughter, and involuntary manslaughter. Murder is the unlawful killing of a reasonable creature under the king's peace with malice aforethought. Unlawful killing means that it is not done in self-defence, as shown in the case of Martin Anthony. This also means that the defendant was not trying to save another individual, as shown in the case of Rie. A reasonable creature is a human being which does not include a foetus as shown in Attorney General's reference No. 3 of 1994. A human being also does not include someone who is on life support as shown in Edel NHS Trust v Blan. Under the King's Peace means that it is done in the UK or by a UK citizen while not a time of war as shown in R.V. Blackman and R.V. Page. There are two types of malice aforethought which are express and implied malice as shown in R.V. Vickers. Express malice aforethought means that the defendant had the intent to kill, which is a form of direct intent. Direct intent is where the outcome was the defendant's main aim, purpose, and desire, as shown in R.V. Mohan. Implied malice aforethought means that the defendant had the intent to cause GBH, which is a form of indirect intent. Indirect or oblique intent is where the defendant saw the possible consequences as virtually certain, but ignored the risk and continued with their actions anyway, as shown in R.V. Woolen. In order to be guilty of murder, the defendant must have both factual and legal causation. Factual causation uses the Buffer test, which proves whether the outcome would have occurred without the defendant's actions, as shown in R.V. White. Legal causation requires the defendant's actions to have a more than slight and trifling link with the outcome and for the defendant's actions to be a more than a minimal causation of the outcome, as shown in R.V. Hughes. Voluntary manslaughter occurs when a person kills someone intentionally but does so in circumstances that reduce their responsibility. There are two types of voluntary manslaughter, which are loss of control and diminished responsibility. Loss of control was established in Section 54 of the Coroners and Justice Act of 2009. Loss of control means that someone has lost control of their actions due to a certain trigger, which does not include revenge, as shown in R.V. Duel. There are two qualifying triggers for loss of self-control, which are fear and anger, as shown in R.V. Ward and R.V. Lodge. There are three restrictions to the defense of loss of control, all of which are shown in R.V. Dawes. The first restriction is that the fear of violence is ignored if it is caused by something that the defendant did with the purpose of providing an excuse to use violence. The second restriction is that the sense of being wronged is ignored if it is caused by something that the defendant did with the purpose of providing an excuse to use violence. The third restriction is that the fact that the defendant's actions were caused by sexual infidelity of a partner, unless there are other factors involved. The defendant's guilt is decided based on an objective test, which asks whether the person of the same age and sex with the same degree of tolerance and self-control would react similarly to how the defendant acted. There are three factors that are also considered, including whether the defendant had epilepsy, depression, or a history of sexual abuse. The court will not consider this defense if the defendant was intoxicated, unless they acted the same way a sober individual would act in their situation. Diminished responsibility was established in Section 2 of the Homicide Act of 1957 and was amended by Section 52 of the Coroners and Justice Act of 2009. Diminished responsibility occurs when there is an abnormality of mind that substantially impairs the defendant's mental ability, which can be both a physical or psychological condition that must be medically recognized and must explain the defendant's act or omission. Abnormality of mental functioning means that the defendant thinks differently to how the normal, reasonable person thinks, as shown in R.V. Bayern. The medical condition must impair the defendant's ability to understand the nature of their action, form a rational judgment, or exercise self-control. This is shown in R.V. Lloyd and R.V. Golds. There are many medical recognized conditions that impairs the defendant's responsibility, including depression, irresistible impulses, battered person syndrome, alcohol dependency syndrome, paranoia adjustment disorder, Othello syndrome, coercive control, premenstrual tension, and mental deficiency. To decide whether the impairment explains the defendant's actions, the court uses an objective test which asks whether someone of the same age and sex would act in a similar way. The defense becomes more complicated if the defendant was intoxicated at the time of the killing and they were intoxicated and have a pre-existing abnormality, or were intoxicated due to an addiction. Although the courts cannot take intoxication into account when deciding the defendant's guilt, the defense of diminished responsibility can still succeed if the main reason for their behavior is their medical condition, as shown in R.V. Gittins. Involuntary manslaughter occurs when a person unintentionally causes someone's death due to reckless or negligent behavior without the intent to kill. There are two types of involuntary manslaughter, including constructive manslaughter and gross negligence manslaughter. Constructive manslaughter, or unlawful act manslaughter, occurs when the defendant commits a dangerous unlawful act and causes the death of an individual. The unlawful act must be a criminal act and cannot be a civil wrong, as shown in R.V. Franklin. As well as this, the unlawful act cannot be an omission, as shown in R.V. Lowe. The unlawful act must be dangerous, which means that there must be some risk of harm which does not need to be serious, as shown in R.V. Church and R.V. Watson. The unlawful act must cause death and therefore requires both factual and legal causation. Factual causation uses the but-for test, which proves whether the outcome would have occurred without the defendant's actions, as shown in R.V. White. Legal causation requires the defendant's actions to have a more than slight and trifling link with the outcome, and for the defendant's actions to be a more than a minimal causation of the outcome, as shown in R.V. Hughes. The defendant must have the mens rea for the unlawful act, which means that they must have intent or recklessness. There are two types of intent, which are direct and indirect intent. Direct intent is where the outcome was the defendant's main aim, purpose, and desire, as shown in R.V. Mohan. Indirect or oblique intent is where the defendant saw the possible consequences are virtually certain, but ignored the risk and continued with their actions anyway, as shown in R.V. Woolen. The defendant may have been reckless in their actions, which is when an individual acts in a way that makes it more likely the harm will occur, as shown in R.V. Cunningham. Gross negligence manslaughter occurs when the defendant breached their duty of care, which caused the death of the victim. The defendant must owe duty of care to the victim, as shown in R.V. Ruffle. The defendant must then breach that duty of care through an omission, as shown in R.V. Misra and Srivastava. This breach of duty must cause the death of the victim, which means that the reasonable person must be able to see that there is a serious and obvious risk of death, as shown in R.V. Wacker. The negligence of the defendant must be gross enough to be considered illegal by the jury, which means that it must be truly exceptionally bad and reprehensible, as shown in R.V. Bateman. There are many non-fatal offences that can be committed against the person, each with a different degree of harm. This includes common assault, actual bodily harm, and grievous bodily harm. Under Section 39 of the Criminal Justice Act 1988, common assault is the combination of assault and battery, which is shown in the case of R.V. Oritzer-Jaffer. Assault is an act that causes the victim to apprehend immediate unlawful force, as shown in R.V. Nelson. For there to be an assault, the defendant must do or say something, as an omission is not enough. This is shown in the case of R.V. Island. The defendant must have both factual and legal causation. Factual causation uses the but-for test, which proves whether the outcome would have occurred without the defendant's actions, as shown in R.V. White. Legal causation requires the defendant's actions to have more than slight and trifling link with the outcome, and for the defendant's actions to be more than a minimal causation of the outcome, as shown in R.V. Hughes. To apprehend unlawful force means the victim fears it is going to happen, as shown in R.V. Lobden. For the force to be immediate, the victim must fear that it is going to happen at some point in the future and not necessarily straight away. This is shown in the case of R.V. Constanza. Unlawful force means illegal harm that would not be used for self-defense or with the consent of the victim. This is shown in the case of R.V. Lamb. The mens rea for assault is intent and recklessness. There are two types of intent, which are direct and indirect intent. Direct intent is where the outcome was the defendant's main aim, purpose, and desire, as shown in R.V. Mohan. Indirect or oblique intent is where the defendant saw the possible consequences are virtually certain, but ignored the risk and continued with their actions anyway, as shown in R.V. Woolen. The defendant may have been reckless in their actions, which is when an individual acts in a way that makes it more likely that harm will occur, as shown in R.V. Cunningham. Battery is the application of unlawful force. The application of force can include the slightest touching, as shown in R.V. Thomas. Battery can be a direct act or an indirect act, as shown in DPP v. K. Battery may also be committed through an omission, as shown in the case of DPP v. Santana Bermudez. Unlawful force means illegal harm that would not be used for self-defense or with the consent of the victim. This is shown in the case of Avayuka. The mens rea for battery is intent and recklessness. There are two types of intent, which are direct and indirect intent. Direct intent is where the outcome was the defendant's main aim, purpose, and desire, as shown in R.V. Mohan. Indirect or oblique intent is where the defendant saw the possible consequences are virtually certain, but ignored the risk and continued with their actions anyway, as shown in R.V. Woolen. The defendant may have been reckless in their actions, which is when an individual acts in a way that makes it more likely the harm will occur, as shown in R.V. Cunningham. The offences against the person act include actual bodily harm, grievous bodily harm, and grievous bodily harm with intent. Under Section 47 of the Offences Against the Person Act, actual bodily harm is assault occasioning actual bodily harm. Assault means common assault, which includes both assault and battery, as shown in the case of R.V. Ireland. Occasioning means causation, which requires both factual and legal causation. Factual causation uses the but for test, which proves whether the outcome would have occurred without the defendant's actions, as shown in R.V. White. Legal causation requires the defendant's actions to have more than slight and trifling link with the outcome, and for the defendant's actions to be more than a minimal causation of the outcome, as shown in R.V. Hughes. Actual bodily harm is actual harm that interferes with the health or comfort of the victim, as shown in R.V. Miller. The mens rea for Section 47 actual bodily harm is intent and recklessness. There are two types of intent, which are direct and indirect intent. Direct intent is where the outcome was the defendant's main aim, purpose, and desire, as shown in R.V. Mohan. Indirect or oblique intent is where the defendant saw the possible consequences as virtually certain, but ignored the risk and continued with their actions anyway, as shown in R.V. Woolen. The defendant may have been reckless in their actions, which is when an individual acts in a way that makes it more likely the harm will occur, as shown in R.V. Cunningham. Under Section 20 of the Offences Against the Person Act, grievous bodily harm is unlawful and malicious wounding or inflicting grievous bodily harm. Unlawful means that it is done without consent and not in self-defense, as shown in R.V. Decker. Malicious means that this is done with intent or recklessness. There are two types of intent, which are direct and indirect intent. Direct intent is where the outcome was the defendant's main aim, purpose, and desire, as shown in R.V. Mohan. Indirect or oblique intent is where the defendant saw the possible consequences as virtually certain, but ignored the risk and continued with their actions anyway, as shown in R.V. Woolen. The defendant may have been reckless in their actions, which is when an individual acts in a way that makes it more likely the harm will occur, as shown in R.V. Cunningham. Wounding means that there has been a break in all of the layers of the skin, as shown in R.V. Eisenhower. Inflicting means that the defendant has caused the wounding or grievous bodily harm, requiring both factual and legal causation. Factual causation uses the but for test, which proves whether the outcome would have occurred without the defendant's actions, as shown in R.V. White. Legal causation requires the defendant's actions to have more than slight and trifling link with the outcome, and for the defendant's actions to be more than a minimal causation of the outcome, as shown in R.V. Hughes. Grievous bodily harm is serious harm which can be physical, psychological, or an infection. This is shown in the case of Brown and Strand. Under Section 18 of the Offences Against the Person Act, grievous bodily harm is the unlawful or malicious wounding or causing grievous bodily harm. Unlawful means that it is done without consent and not in self-defense, as shown in R.V. Decker. Malicious means that it is done with the intent to cause grievous bodily harm, as shown in R.V. Taylor. This also means that it is done with the intent to resist or prevent a lawful arrest, as shown in R.V. Morrison. Wounding means that there has been a break in all of the layers of the skin, as shown in R.V. Eisenhower. Causing means that the defendant has caused the wounding or grievous bodily harm, requiring both factual and legal causation. Factual causation uses the but for test, which proves whether the outcome would have occurred without the defendant's actions, as shown in R.V. White. Legal causation requires the defendant's actions to have more than slight and trifling link with the outcome, and for the defendant's actions to be more than a minimal causation of the outcome, as shown in R.V. Hughes. Grievous bodily harm is serious harm which can be physical, psychological, or an infection. This is shown in the case of Brown and Stratton. There are 3 offences against property, including theft, robbery, and burglary. A person is guilty of theft if he dishonestly appropriates property belonging to another with the intention of permanently depriving the other of it, as stated by Section 1 of the Theft Act. Appropriation means to take something, with Section 2 of the Theft Act stating that there must be a clear point in time when the appropriation takes place, which should link to when the mens rea is formed. This was shown in the case of Pitham and Hale. Property includes money and all other property, real or personal, including things and other intangible property, as stated in Section 4 of the Theft Act. This is shown in the case of Kelly v. Lindsay. Property shall be considered as belonging to any person having possession or control of it, or having in it any right or interest. This is shown in the case of R.V. Turner. This must be done dishonestly, which is not defined by the Theft Act. However, there are 3 subjective tests to help prove this. The first subjective test is that the defendant believed that they had a right in law to take the property, as shown in the case of Robinson. The second subjective test is that the defendant believed that they had the owner's consent to take the property. The third subjective test is that the defendant cannot discover the owner of the property by taking reasonable steps, as shown in the case of Small. The defendant must also have the intention to permanently deprive. If the defendant destroys someone else's property, then this is intention to permanently deprive the owner of its use or value. If the defendant offers the property for a price, this is theft as the defendant is treating the property as their own, as shown in the case of Raphael. Robbery is defined by Section 8 of the Theft Act as a person stealing and immediately before or at the time of doing so, and in order to do so he uses force on any person or seeks to put someone in fear of being then, and they're subjected to force. In order for there to be a robbery, there must be a completed theft with the intention to steal, which is the dishonest appropriation of property belonging to another person with the intent to permanently deprive, as described in Section 1 of the Theft Act. This is shown in the case of R.V. Robinson. For there to be a robbery, the defendant must use force, which could either be a battery or an assault. This is shown in Corcoran v. Anderton. This force must be used during the theft or immediately before the theft takes place. This is shown in R.V. Vinor. The force can include the slightest touching or force applied to an object that the victim is in control of. This is shown in R.V. Clarden. The threat of force is also sufficient for a robbery, as shown in R.E.D. In order for there to be a robbery, the force used or the threat of force must be used with the intent to use this force to steal. This is shown in R.V. Bentham. The force or the threat of force does not need to be used on the person that the property was stolen from, as shown in Smith v. Desmond. If the defendant pulls or snatches the property without making contact, then this does not constitute force and is therefore not a robbery, as shown in P v. DPP. If the defendant uses force after they have completed the theft, then this is not considered a robbery as the force is not used in order to steal the property, as shown in R.V. Lockett. Burglary is defined under Section 9 of the Theft Act 1968. It involves entering a building or part of a building as a trespasser with the intent to commit certain crimes. Entry is not defined in the Theft Act but has been interpreted by the courts. The entry does not need to be substantial, but it must be effective, as shown in R.V. Brown. Entry can also include being partially inside a building, as shown in R.V. Ryan. The building includes not only houses, but also structures like vehicles or vessels used as living spaces. A building can be any structure that is intended to be permanent, as shown in Stevens v. Girl. A vehicle cannot be considered a building if it has wheels, even if it is used for storage, as shown in Seekings v. Good. The defendant must enter without permission or legal authority, as shown in R.V. Collins. If permission is exceeded, they become a trespasser, as seen in R.V. Jones and Smith. For burglary, the defendant must have the intention to steal, inflict damage, or cause criminal damage. Under Section 9, 1a, the intent must exist before entry, while under Section 9, 1b, the intent can form after entry. Attorney General's references 1 and 2 of 1979 clarified that conditional intent to steal is sufficient under Section 9, 1a. Mental capacity defenses are legal defenses where a defendant lacks the mental capacity to be held fully responsible for their actions, such as automatism, insanity, and intoxication. Non-insane automatism occurs when the defendant commits a crime while in an automatic state where the mind had no control over the muscles. The case of Bratty v. Attorney General for Northern Ireland set out the Bratty test, which has parts that must be met for the defence to be used. The first part of the Bratty test is that there was an involuntary action caused by an external source or reflex action, as shown in R.V. Kemp. Examples of external factors include a blow to the head of a swarm of bees, sneezing, hypnotism, and the effect of a drug. The second part of the Bratty test is that the act was completely involuntary, as shown in Broom v. Perkins. The defendant must have lost total voluntary control of their actions, and partial loss of control is not sufficient. The third part of the Bratty test is that the automatism was not self-induced, as shown in R.V. Bailey. Self-induced automatism occurs when the defendant knows that their conduct is likely to put them in an automatic state, such as with voluntary intoxication. Self-induced automatism affects specific and basic intent crimes differently. Specific intent crimes are any offence with a mens rea requiring intent, such as murder, whereas basic intent crimes are any offence with a mens rea requiring recklessness, such as common assault. Self-induced automatism can be a defence for specific intent crimes as the defendant lacks the mens rea for the offence, but it cannot be a defence for basic intent crimes as the defendant was reckless in putting themselves in an automatic state, as shown in R.V. Hardy. Insanity is a defence where the defendant can be found not guilty by reason of insanity. The case of R.V. Amnatan sets out the three-step test to prove the defendant is insane. The first step is that there was a defect of reason, which means that the defendant's powers of reason must be impaired, as shown in R.V. Cluck. If the defendant is capable of reasoning but fails to use those powers, then this is not a defect of reason. Mere forgetfulness or absent-mindedness is also not sufficient. The second step is that the defect of reason was caused by a disease of the mind, which includes any physical disease that affects mental functioning as shown in RV Chem. The third step is that the defendant did not understand the nature and quality of the act and did not know it was wrong. Not understanding the nature of the act means that because of the defect of reasoning, the defendant did not understand the actual type of act they were doing, whether that be because they were in a state of unconsciousness or due to a mental condition as shown in RV Antoine. Not understanding what they were doing was wrong meant that the defendant did not appreciate that what we're doing was wrong in the law, as shown in RV Windle. If the defendant successfully proves insanity, the jury must return with a verdict of not guilty by reason of insanity, and the judge can impose hospital order, supervision order, or give an absolute discharge. Intoxication is a full defense based on whether the defendant had the required mens rea for the offense. The lack of mens rea could be due to intoxication by drugs, alcohol, or any other substance. Intoxication can be voluntary or involuntary and affect specific and basic intent crimes. Specific intent crimes are offences that require intent for the mens rea, such as murder, whereas basic intent only requires recklessness for the mens rea, such as common assault. Voluntary intoxication can negate the mens rea for specific intent crimes and can lead to the defendant being acquitted for their charges if they lack intent, as shown in DPP v. Beard. However, if there is a fallback offence, such as manslaughter being the fallback offence for murder, then the defendant may be charged for the fallback offence instead. Voluntary intoxication has no effect on basic intent crimes as it is seen that becoming intoxicated is reckless, as shown in DPP v. Majewski. Involuntary intoxication can occur if the defendant does not realize the strength of the intoxicant they are taking, they are spiked, or their prescription drug has an unexpected effect, as shown in RV Allen. If the defendant is intoxicated through no fault of their own, they can argue that they did not form the mens rea for the offense for both specific or basic intent, and they will be acquitted. However, if the prosecution proves that the defendant did form the mens rea for the offence at some point before or after the intoxication, then they will be found guilty, as shown in RV Kingston. If the defendant is so intoxicated that they get a key fact of the situation wrong at the time, then they can rely on the defence if the offence is one of specific intent. If the offence is one of basic intent, and they do not have the mens rea for the offence, then there is not defence, as shown in RV Hatton.
There are 4 different defenses that can be used, which are self-defense, duress by threats, duress of circumstances and necessity, and consent. The defense of self-defense is a legal justification that allows a person to use force to protect themselves, another person, or property from an unlawful attack. The first element of self-defense is that the defendant must be facing an unlawful threat, as shown in RV Gladstone-Williams, where the defendant mistakenly believed someone was being assaulted. The second element of self-defense is that the force used must be necessary, as shown in RV Bird, where the defendant was not required to retreat before defending herself. The third element of self-defense is that the force used must be reasonable in the circumstances, as shown in RV Palmer, where the court held that a person defending themselves cannot be expected to weigh the exact measure of force in the heat of the moment. Self-defense can be applied under both common law and statute, including the Criminal Law Act 1967 and the Criminal Justice and Immigration Act 2008, where it protects those who use necessary and proportionate force. Reasonable and necessary force means the level of force used must match the circumstances as the defendant honestly believed them to be, as shown in RV Oweno, where the court stated that the force must be objectively reasonable in the circumstances. The defense of duress by threats is a complete defense that excuses a defendant who commits a crime because they were forced to do so by threats of death or serious injury. The first element of duress by threats is that the defendant must face a threat of death or serious injury, as shown in RV Valderrama Vega, where other pressures were ignored unless the threat involved death or serious harm. The second element of duress by threats is that the threat must be directed towards the defendant, their immediate family, or someone they are responsible for, as shown in RV Wright, where threats to a boyfriend were considered sufficient. The third element of duress by threats is that a reasonable and sober person with the same characteristics as the defendant would have acted in the same way, as shown in RV Bowen, where characteristics such as age and gender were considered relevant. The fourth element of duress by threats is that the defendant must have no safe avenue of escape, as shown in RV Gill, where the defense failed because the defendant had a chance to go to the police. The fifth element of duress by threats is that the threat must be operative at the time of the offense, as shown in RV Hudson and Taylor, where the court accepted that the threats could still influence the defendants even when not immediate. The defenses of duress of circumstance and necessity both excuse a defendant who commits a crime to avoid a greater harm, but duress of circumstance involves threats arising from the situation, while necessity involves choosing the lesser of two evils. The defense of duress of circumstance allows a defendant to commit a crime because of a threat created by the surrounding circumstances rather than a person. The first element of duress of circumstance is that the defendant must reasonably believe they or another are facing death or serious injury, as shown in R.V. Martin, Colin, where the defendant drove while disqualified to save his suicidal wife. The second element of duress of circumstance is that a sober and reasonable person sharing the defendant's characteristics would have acted the same way, as shown in R.V. Conway, where the defendant drove dangerously believing his passenger was about to be shot. The defense of duress of necessity allows a defendant to commit a crime to prevent a greater harm from occurring. The first element of duress of necessity is that the act must be done only to prevent inevitable and irreparable evil, as shown in Re F. Mental patient sterilization, where doctors acted to protect a patient from harm. The second element of duress of necessity is that the act must be reasonable and proportionate to the harm avoided, as shown in Re A. Conjoined twins, where separating the twins was necessary to save one of their lives. The defense of consent is a defense that allows a defendant to avoid liability if the victim freely and genuinely agreed to the act that caused harm. The first element of consent is that the victim must give valid and informed consent, as shown in R.V. Thibasum, where the consent was invalid because the victims were deceived about the nature of the act. The second element of consent is that the consent must be genuine and not obtained through fraud, fear, or mistake, as shown in R.V. Richardson, where a suspended dentist's patient still gave valid consent because they knew his identity. The third element of consent is that it is generally not a defense to actual bodily harm or greater injuries unless the activity falls within an accepted exception, as shown in R.V. Brown, where consent was not accepted for sadomasochistic acts causing injury. The fourth element of consent is that it may be valid in activities like sport, medical treatment, or lawful correction, as shown in R.V. Barnes, where injuries sustained during a football match were considered potentially lawful due to implied consent. An attempt is where the defendant, with intent to commit an offense, does an act that is more than merely preparatory as shown in the Criminal Attempts Act 1981. The actus reus of an attempt is where the defendant does an act that is more than merely preparatory as shown in Gulliver. The mens rea of an attempt is where the defendant intends to bring about the full offense as shown in Whybrow. Impossibility is where the defendant tries to commit an offense that cannot actually be completed due to factual or legal reasons. Factual impossibility is where the defendant believes their actions will commit a crime, but completion is impossible due to a factual mistake. The first element of factual impossibility is where the defendant intends to commit the offense but the facts make it impossible as shown in Shivery. The second element of factual impossibility is where the defendant can still be guilty despite impossibility under the Criminal Attempts Act 1981 Section 1, 2. Legal impossibility is where the defendant believes they are committing a crime, but the act is not actually a crime in law. The first element of legal impossibility is where the defendant's conduct is not actually unlawful as shown in Taff. The second element of legal impossibility is where the defendant's mistaken belief cannot create criminal liability because the act is legally permitted. There are many benefits and drawbacks to the law of non-fatal offences and defences. There are also many ways that these laws can be reformed. The advantages and disadvantages of the law on non-fatal offences against the person are that it offers a clear hierarchy of offences allowing proportionate sentencing, but it is outdated, uses archaic language and fails to reflect modern understandings of harm. The law on non-fatal offences against the person is fit for purpose according to some as it provides necessary legal structure, but others argue it no longer meets the needs of a modern justice system. The law on non-fatal offences against the person is up to date according to defenders of the current framework, yet critics argue it relies on Victorian terminology and concepts that do not reflect current medical and social developments. The law on non-fatal offences against the person is just in that it can deliver proportionate punishment, but it is also unjust because unclear statutory definitions often produce inconsistent outcomes. The law on non-fatal offences against the person is effective as it enables the prosecution of offenders, but it is ineffective because its complexity often confuses juries and leads to appeals. The law on non-fatal offences against the person balances principle and policy according to some, yet it frequently prioritizes public policy over individual rights, undermining legal certainty. The law on non-fatal offences against the person is fair in its aim to treat harms equally, but in practice it is unfair as it results in disparities and uncertainty for defendants and victims. The law on non-fatal offences against the person is based on sound moral principles in its attempt to reflect societal views on personal harm, but its foundations are rooted in outdated moral assumptions that may no longer apply. The advantages and disadvantages of the law on intoxication, self-defense, and consent against the person are that they attempt to balance individual autonomy and public protection, but they are inconsistent, complex, and often lead to unpredictable outcomes. The law on intoxication, self-defense, and consent is fit for purpose according to supporters who argue it protects society and sets clear limits on behavior, but critics claim it fails to reflect modern social realities and the complexity of human decision-making. The law on intoxication, self-defense, and consent is up to date in some respects due to statutory developments, but many elements are outdated and rely on Victorian principles that do not align with contemporary societal values. The law on intoxication, self-defense, and consent is just as it seeks to proportionately judge defendants based on their mental state and actions, but it is unjust where rigid rules ignore individual circumstances. The law on intoxication, self-defense, and consent is effective because it provides legal mechanisms to deter harmful conduct, but it is ineffective when its complexity causes confusion and inconsistency in verdicts. The law on intoxication, self-defense, and consent balances principle and policy by attempting to uphold individual rights while maintaining public safety, but it often favors policy concerns at the expense of coherent legal principle. The law on intoxication, self-defense, and consent is fair in that it aims to treat defendants and victims equally, but it is unfair due to disparities in how the legal rules are applied. The law on intoxication, self-defense, and consent is based on sound moral principles in its objective to regulate responsibility and protect bodily integrity, but it is also rooted in outdated moral assumptions that may not reflect modern ethical standards. Ideas for reform on the law of non-fatal offences against the person include replacing the outdated Offences Against the Person Act 1861 with a modern statute using clear language to solve the issue of uncertainty, introducing a tiered structure based on the harm caused rather than archaic offence labels to solve the issue of inconsistency in sentencing, and defining key terms such as grievous and actual bodily harm in statute to solve the issue of reliance on outdated case law. Ideas for reform on the law of intoxication include introducing a consistent statutory definition of voluntary and involuntary intoxication to solve the issue of unpredictability in verdicts, removing the distinction between specific and basic intent offences to solve the issue of confusion for juries, and creating a partial defence for those whose intoxication stems from addiction to solve the issue of unfairness towards vulnerable defendants. Ideas for reform on the law of self-defense include setting a clear statutory test for reasonable force to solve the issue of inconsistent jury interpretation, clarifying the law on preemptive strikes to solve the issue of uncertainty in situations where a threat is imminent, and defining the limits of householder defense to solve the issue of disproportionate force being justified under vague principles. Ideas for reform on the law of consent include introducing a statutory definition of consent that applies across all offences to solve the issue of inconsistency, creating clearer rules around consent in situations involving serious harm to solve the issue of unclear limits on personal autonomy, and establishing a statutory list of circumstances where consent is invalid to solve the issue of uncertainty arising from case-by-case judicial decisions. Thank you for watching this video on the legal system and criminal law. I'll see you in the next one.